Just making sure the live stream is working. And here comes everyone. Good morning. I'm Judge Person. I do welcome everyone to court this morning, if you could. And I want to thank everyone for their time. Just a little late start, just a technological thing. And we're having pretrials. Remember that pretrials are by agreement online, and want to have a in-court proceeding instead of this proceeding. That's perfect to the court, but you'll need to let me know. Otherwise, I'm just assuming everybody's comfortable with this intermediary step being here. For convenience is what we're just doing that for. So, Mr. Metzen, I'm going to go ahead and start with your pretrial docket. That's the main portion of our docket today. And again, I'm Judge Person. And I do welcome everyone to the court this morning. Mr. Metzen, I was watching as folks logged in, so I'm going to go ahead and get you started. Mr. Grisham, I have you on 2 devices, which is fine, and that works for the court, but I don't know which one you want me to unmute. I'm going to start. There you are. Great.
Your Honor, this is my only account. The Chris Grisham account is my client.
I'm sorry. I apologize. That's right. So give me a moment and let me ask you, would you like Mr. Chris Grisham to come in the pretrial breakout room with you?
Yeah, if we do a pretrial breakout, yes, ma'am.
Yeah, that's what we're doing this morning.
Yes, ma'am.
So yes, and I'm going to go ahead and make sure his microphone is working. Mr. Chris Grisham, I just sent you an unmute request. Are you able to make that happen, hopefully?
Chris, are you able to unmute? I think this is his first time on Zoom, so
the button should have popped up for him to click on, but as a pretrial matter, it may not be necessary. I'm going to go ahead and move y'all into the pretrial room, the 3 of y'all together with Mr. Metzen.
Thank you.
Mr. Metzen, I know your microphone is working, and I'm moving all of y'all over. After y'all meet, you'll move back over to this quote room. And what I'll say about that is if you're unable to make that movement, I will do it manually. So just be patient with the court. Okay. That should be moving forward. And I have a late person, but I'm going to let them in. I have a few folks that I'm not able to identify, and I just want to check in and make sure that I know who's who today. So let's see. Zoom user, young person, short brown hair. I just sent you an unmute request. Can you unmute and tell me your name?
My name is Logan Mayberry.
Okay, Mr. Mayberry, I'm just going to change your name for the purposes of this meeting. It'll go back to what you had before after the meeting. But that's just so that I have you in line, so to speak. And I'm making notes of that.
Yes, ma'am.
Thank you. I'm going to remute you until it's your turn. Okay. I'm about to give just kind of some announcements in a moment, but I'm still confirming. A gentleman with a red shirt, iPhone, it says, and if you could unmute and give me your name, that would be great.
How you doing, Judge? Good morning. My name is deferred Marshall.
Okay, Mr. Marshall, thank you so much. I'm just changing it for this meeting.
Yes, ma'am.
And it'll go back to what it was before, but I just want to, I'm sort of watching as people log in, and I kind of keep a line, so to speak. And so I'm just going to remute you till it's your turn, okay? And then I had another one, but it looks like that resolved. And if I could, Dorothy Butler, are you here with the Lawrence Law Firm or for Mr. Lawrence?
No, this should be, it's not for, it's, let me confirm because I'm with 2 firms. It's for Janaea West is who I'm here on behalf of.
Okay, I had Janaea Jones, which may be a prior name, but that's the name that we have on the file. Janaea LaRae Jones.
I confirm if that's a different name.
Don't think so. Yeah, I have you as the attorney as Dorothy Lawrence.
That's it's just that was my formerly married name. So yes, we got the same. We're on the same client.
Okay, okay. If you have a name change, like if you have something that, like a license, then I can change our name file, okay? For Miss, you're now using the name West. Is that right?
No, it's Butler. It's not been legal. It's
For your
not been
client.
legally.
I
It's not,
apologize. I apologize for your client. Your client's name?
my client that we had. It's under Janaea West.
Right. So let me just look at that for a quick moment. These are cases from 2017. So what I'm saying is her name may have changed. And if you have a license or something from the state that shows that name change, I could probably change the name file, but the name at the time was Janaea Jones. And I'm just trying to clarify so that we're all on the same page.
I will. I don't know if I have a copy of her license in the file, but she has a slew of tickets. I'm sure it's the same Janaea.
Okay, yeah, we're gonna use the name Jones until further notice, okay?
All right. Thank you.
Okay, great. Thank you very much, Ms. I will use the name Butler if that's preferred.
Yes, thank you.
Okay, let's see. Let me just change that. Okay, great. So I am actually looking for Jamia DeShields. Are you here today? Okay. So that is actually the only thing that I have for my quote line. Just a handful of things that are helpful to know, just options speech, okay? And also rights and duties. So I just want to let you know that this is a Class C court. The cases filed here are only Class C offenses. That main distinction between a Class C and other types of offenses, even though this is a state court, the cases that are filed here, they're Class C offenses, which means that they can result in the imposition of fines and costs, but normally not jail time. Mr. Grisham, I see that you're back with Mr. Matson, and your client is back over too. So let's go ahead and just check in as to where we are with regard to this particular matter, the accusation being a speeding charge from February 7th of 2024 with fines and costs of $254 if they were to be paid, for example, at the window. So where are we with regard to that matter?
Judge, Mr. Grisham has an offer he's going to discuss with his client. So I think it'd be best if we reset to the next Zoom hearing, give them time to
Okay.
do that.
Mr. Grisham, does that meet your expectations?
Yes, Your Honor.
Okay, my next available, and I know that, you have a busy schedule. So
I'm
let's,
all over Texas.
yeah, I understand that from our communications. I appreciate you staying on top of that very, very much, by the way. So the next available pretrial is going to be, on my calendar, I have two options. Well, I have three. April 23rd would be an option.
Let's go ahead and take that one, Your Honor.
Okay.
I'm open that day and let's make it unopened.
Okay, we'll go ahead and grab your spot while we can.
Judge, is April 23rd a Zoom hearing or is that a live court date?
Oh, I apologize. That's a live date. Excuse me, April 30th.
Oh, April 30th. Let me see. Oh, I'm good that day too, Your Honor.
Okay, very good, very good. Okay. Mr. Matson, thank you for grabbing that to my attention.
Welcome.
And can we send that to gentlemen to the email that we have on file?
Yes, ma'am.
Okay, very good. That's the one we used for today. And then you make that available to your client. That's perfectly great for the court, unless you need us to send it.
No, ma'am. And actually you don't even need to send anything. I've got it. It's in my calendar and I will inform my client.
I will send it. I'll tell you, we send the link and our links don't stay the same. They change by docket.
Oh, okay. Yes. Then
So
I guess
we'll
I do
send
need
it to you because that's the one you want to use. I just want to make sure you know that because that is a little different from, say, the district courts. They I think they have like one channel, and we just do them on a calendar because we have a lot of folks, and I don't have a waiting room space. I just, to me, it's better. Everybody sees everybody, and it's more like court-ish, and I like that feeling.
Yes,
So
ma'am.
we're going to keep it that way, and it'll come to your email. And if you need us to send it to your client, you can let us know.
Thank you, ma'am.
All right. Is
Thanks, Ryan.
Sir.
tell both. Is there anything further from either party?
Not from the
Nothing to say,
defense, Your
Judge.
Honor.
Okay, y'all are, Mr. Grisham, CJ Grisham, you are excused with the thanks of the court. Mr. Chris Grisham, you are also excused, which means you can just hang up. Your attorney will talk to you about what's happening. I'm sure he'll keep you informed.
Thank you.
Thank you both. Mr. Mattson, you're moving forward, and the next person was Nathan Hernandez's case. Mr. McMahon, or I'm sorry, Mr. Kelly. I will move you over to that meeting with Mr. Mattson.
Thank you, Judge.
Mr. Martin, I'm sorry.
It's all right.
Sorry, I've said it wrong 3 times. I know your name. I'm just getting flummoxed by the long name there. Okay, there we go. Okay. So just back to the distinctions and differences between, and it's important because there are certain rights that you have that attach to different, proceedings. So what I'm letting you know is that the Class C court distinction, really the biggest difference, there are a few small differences, but the large one is that you're normally not sentenced to a jail time amount if you are to be found guilty at some point. So that's the biggest distinction. Another distinction that's quite big is that you're entitled to meet with an attorney of your choice. In other words, if you want time to meet with an attorney, you have that right to do that. In Class C courts, it's not court-appointed counsel, but you have the right to recess your case. That means just put it on hold for a minute, for a few days, and meet with someone. It doesn't obligate you to hire someone. It doesn't mean that when you come back, if you decided not to hire that person or persons, that, you would be scolded, but it does mean that your case would be put on hold. We would reschedule for another date. And when you come back, you're either represented or you're not, and we move along generally at that point. If you didn't know that, or you need some time to explore that option, you need to let me know this morning so that we can take that time. And the way that you do that, the way you invoke that right, is you just say, Judge, I need some time, and I'll give you that time. So let me know. If otherwise, I assume you're not needing to do that, I'm permitted to make that assumption, and we just move forward. Okay. So hopefully everyone understands that. Does anyone have any questions about that? Okay. So the next thing I want to let you know about is just generally how things flow through a court. Now, I cannot give legal advice. You are welcome to ask questions about your case. I can answer certain questions that constitute legal advice, though. Judges and the state attorney, we're not permitted to answer those. So Mr. Mattson, I'm just struggling with names today. I do apologize. I like to get people's names right. Mr. Mattson, who represents the state of Texas, he's kind of the equivalent of a DA, except at the city level. So he's not my employee. He does not answer to me in any way that's related to his paycheck. In court, he has to follow the court's rules like anyone would. But as far as like answering to me assigning his work duties, I'm not the person who does that. He answers to the city attorney, just as an associate district attorney would answer to a DA, a district attorney. And the city attorney is his supervisor boss. Okay. Good to know that, but also when you meet with him, he's not your attorney. He doesn't represent you. He can't give you legal advice. Now, if you ask questions, and you're welcome to, it's your case. If it's something that encroaches on that idea of legal advice, I'll just pause and explain, hey, I'm not able to answer that. It's legal advice. Are you trying to meet with an attorney first? I'll explain. So it's your case, and that doesn't mean you can't ask questions. Don't be nervous about asking questions. Just know that if it's something that is improper for me to answer, I'll just let you know. Okay. So you can ask. And no one's going to get upset about that. Okay. But the other thing I want to let you know is as we move forward, generally speaking, when people come into a Class C court, a ticket is considered to be an accusation. Or if you were given or sent a summons in the mail, that also is a method of accusation. And when you give a plea, you're giving your answer, you're giving your response to the accusation. And pleading, there are basically three options for pleading. If you plead guilty, you are admitting an offense. You're saying, I did this. If you plead no contest, you're not admitting it, but you're not denying it either. You're moving your case forward into sentencing. That is the effect of a no contest plea, is that it moves the case into sentencing without agreeing or disagreeing with the accusation. If you plead no contest or guilty, I move that case into sentencing. If you plead not guilty, you're just maintaining that innocence that the law presumes, and that will move your case toward trial. Everyone here right now has entered a not guilty plea, and there's no problem with that. The next setting, if the case isn't resolved today, is generally we come on into court, we do any additional in-court pretrial matters such as discovery, such as any kind of motions that are needing to be heard prior to trial. And we also the court schedules a bond in order to, just secure attendance at trial. Generally, you're not going to be expected to make payment at that point. Okay. That's generally the rule that I follow. It's just generally we do some paperwork and a promise to appear. Okay. So we will do that in court because it's a more contested proceeding. This is a check-in, and check-ins are good by agreement if people want to do them, because sometimes it's not necessary to make a trip over to the court. And if we can avoid that for you, we're more than happy to do that just as a convenience. But if you want to come in for your pretrial, you don't even have to do this proceeding. The next step we will take, though, will be here in the courtroom. Mr. Matson and Mr. Martin, I finally got it right. I want to check in with y'all on Nathan Hernandez. Give me just a quick moment to pull that file. Where are we with regard to this single charge of turning when unsafe, alleged from February 3rd, 2024?
Judge, Mr. Martin just received discovery.
Okay.
So I think it'd be best if we reset so he has a chance to look over everything, and then we can have a better, more informed discussion at that time.
That's fine. Mr. Martin, let me ask you, would you prefer to have a live setting or an online setting for that next meeting?
Online, please, Judge.
Okay, I have April 30th. I also have a slot for April 16th.
I think April 30 is perfect.
Okay. Mr. Matson, any objection?
No, Judge.
Okay, then I will place it there and send the meeting link to you, Mr. Martin, at the email that we used for today, unless there's a different one.
No, that's fine, Judge.
Okay, I'll let you get going.
Thank you.
You're good when you're ready to exit.
Have a good day.
And you too. And Ms. Butler, I'm moving you over to that meeting. I know you have on a video that works as well. So I'm moving that over to, we've already checked her devices are working, Mr. Matson. So she's good to move over, I believe.
Yes, I'm here.
Great. Okay. And so just back to what we were talking about, if you plead not guilty, we're moving that case into the courtroom. Generally, in the next setting, you can see where I'm making some exceptions to that this morning, and it does depend a little on the case. If people are, if the attempt is to try to resolve it, sometimes we can get that done more easily because it's by agreement. That's really what drives coming into court. When parties are not agreeing, it's not an issue. That's what courts do. But, generally speaking, face-to-face is really the best method for that, because disagreements have a lot of nuances to them. That's really my short-winded answer to that. And there's legal reasons why we come on into court. But let me talk a little bit more about dismissal options. I think it's good to understand what they are. You have 4 options available in a Class C court. It does work differently from other types of courts, like your felony courts or your higher level misdemeanors. There are 4 dismissal options here on pleas of guilty or no contest that come directly from the judge, okay? And that is compliance dismissals, driver safety course options, deferred dispositions, and teen court. I'm not sure, there's 1 or 2 people that I guess could be teen court. Let me check. Mr. Mayberry, are you still in high school?
Yes, ma'am.
Okay, listen, when I get to the teen court option, I'll go ahead and go into it here in a moment. If I don't have high school students, I don't go into it unless I have GED students. Is there
Okay.
anyone here? Thank you so much. Is there anyone here working toward a GED as well? Okay, or still in high school? Okay, I wasn't sure with him, but it's not unusual for young people to be here and they are, technically over 17. That does happen. And you're still eligible for what is known as teen court. And I'll describe that shortly. So let me just go through these options and just briefly how they work. If you have a compliance dismissal, like registration, for example, I do see some registration charges on today. If you have a compliance dismissal, that's an example of one. That is something that under the law, if you're able to bring it up to date on time for court and pay certain fees with the state of Texas and bring that paperwork to us, we start moving towards a dismissal. And there's about 14 of those in the code books. If you plead guilty or no contest, the clerks out front, you might have met them. You might not have, but if they're out there, they're generally looking for that because we know that people would prefer to get their case dismissed instead of paying it. So if it looks like you're eligible, we are actually tasked with trying to sort those out. So we do that, but that duty for us to do that here doesn't kick in until someone pleads guilty or no contest. So it may be that you could be eligible under the right circumstances, but they didn't talk to you about it because it's not triggered yet. Okay, so that's something you can discuss with the prosecutor, whether it's eligible for that treatment and can we get you to that point? Or did you miss an element such as being late for court? You can talk to the prosecutor about that. He may or may not grant that. He can make a recommendation. I can look at it and talk to you about the option on a plea of guilty or no contest. So there's kind of 2 ways to bite at that apple. Okay, but generally speaking, we look at those and see if we can sort them quickly with you. We try to do quick things where we can for folks. Now, the second way to gain a dismissal is if you have a moving violation, you can do a driving safety course option. And it's actually a good time to talk about money. So money's not a favorite topic of like anyone, but we do it all the time over here at the court. So if you have a moving violation and you're eligible for a driving safety course option, if you plead guilty or no contest, again, we start telling you, hey, do you want to do that? We can't make you do it, but it's a pretty good option. Let me talk about how it works. And to do that, I just need to tell you that every ticket, like if you called the clerk and said, how much is this ticket? And the clerk might have said like $269, and you think, wow, that's a lot of money. Where does that go? And the answer is some of it goes to the state of Texas and some of it stays over in Temple. So you pay a court cost. Every ticket has a court cost and a fine. And the court costs go to the state of Texas and the fine is local. The court costs are set by the state of Texas through the legislature, and the fine is set by the judge of the court. That would be me. When you do the driving safety course option, you pay the court costs because guess what? The state of Texas gets paid first, right? Big surprise. And you come back with a course completed and your driving record completed, and it's got to be the right course and the right record. And we give you information so that you know what to do. But your court cost and your record come in on time. You've got a window There's a window of 90 days to get it done. You can turn it in on the 90th day, but I strongly recommend that people do it as early as possible, because people have a tendency to forget. And your court costs then go to the state of Texas. If you get your course and your record in, the ticket is dismissed, and the fine that just is sitting on hold, it gets waived and you don't pay it. It's cheaper to do that than to pay your whole ticket, and it does keep it off of your record. And you do have to be eligible for that program. And if you plead guilty or no contest, we automatically check if you're eligible. And so if you have questions about that, I'll entertain those in a moment. Mr. Mattson and Ms. Butler, where are we with these? I believe it's just 2 charges on I have Jones in my file, and I'm just gonna use that name for now. On Janaya Jones. Where are we with regard to those matters?
Your Honor, Ms. Butler's going to take an offer back to her client.
Okay,
If we could get a reset, I think April 30th is probably sufficient for that.
okay. Ms. Butler, is that a good date for you in terms of Zoom?
Let me just double check. Yep, totally open as of now.
Okay, we will entertain everything at that time on Zoom. Can we send it to the email that we have on file for you?
Yes, that'll be fine.
Okay, then I will make that change and we'll all be back here in a few weeks. Okay?
All right. Thank you, Your Honor.
You're good to go whenever you're ready.
Thank you.
Thank you. Mr. Mattson, I'm just going through the dismissal options. I think I would like to complete that before I move you forward, because I don't see any repeat folks here, and I just want to make sure they have the benefit of the introductory information before we move forward. Just about to wrap that up. So where I was with the driving safety course option is, if you have questions about that, generally speaking, I can answer those questions. I can't dive into the facts of your case, but I can talk to you about that, as can Mr. Mattson. The third option is called a deferred disposition. Deferred means delay, and disposition means to make final. And if you get a deferral, then I put a court order in place. It will list the things that need to be done in order to earn the dismissal. They will be in writing so that you know what they are. There's no gotcha on that. You sign it, I sign it. Generally speaking, at this stage, the prosecutor is also going to sign it. So that means that everybody's going to need to agree to that. But the way that you receive a deferral at this stage is you talk to the prosecutor about it. You're not, he is not obligated to make that as an offer, but it is a delay where you don't get tickets, you don't get citations. Sometimes there's a class, sometimes there is a record, sometimes there's a document of some sort that we need. If your address stays current, or if you move, we need to know. And generally speaking, good behavior, we sort out payment as well. And at the end of the day, if you meet the obligations that are listed on your deferred order, we dismiss the charge and it's not a conviction against you. The way that you get or receive a deferral in a Class C court is you can either agree with the prosecutor, come to an agreement and bring it to me, and I generally will follow it. Or if you plead guilty or no contest, you can ask the judge directly, guilty or no contest, I would like a deferred. You may ask the judge on those pleas of guilty or no contest. Okay, hopefully that made sense. Mr. Mattson, your next person is Zachary Hug. Mr. Hug, can you unmute and get on screen?
Hello.
Hi, are you able to get on screen? You have
On
a
video, yes.
There you go. I'm going to move you over to that meeting prosecutor. I think you'll find it helpful if you don't walk around while you do the meeting, because it challenges your device. And often you'll lose audio. Here we go. And then the last option is teen court, and I may have just 1 or 2 folks eligible for that, but you need to be in high school, middle school, or homeschooled in order to do teen court. It's very similar to a deferral in that there are things to do to earn that dismissal, that it is on a plea of guilty or no contest. If you want teen court, I do have to shift, the direction because right now the cases are heading to trial. But on a plea of guilty or no contest, teen court is an option. Instead of the court costs, which are not cheap, even on the driving safety, the court costs are about 160. They range from 135 to 169. In the teen court option, it's a $20 fee. And then we look at things that you're going to do in order to gain a dismissal. But we do that on a plea of guilty or no contest. Mr. Mayberry, you are able to talk to the prosecutor about it if you wish. On a plea of guilty or no contest, you're able to ask me about it. And I don't think Ms. Mungia is getting a GED. And I doubt she's in high school. So I don't think anyone else here appears to be eligible for teen court. So those are really the 4 ways to gain a dismissal. And I just like people to know that before we start things off. I know it's a lot of talking, but it does tend to answer lots of questions and let people know. And that way everyone's on the same page as we begin the journey of heading through the cases. And as I say, you have the right to a trial, and you can have a jury decide your case or a judge decide your case, but the law presumes a jury. And we do that paperwork here in the courtroom, and we'll schedule that if the case is not looking like it will resolve today. That's perfectly fine. Okay, I will just sit here and work because I actually don't have anyone here to meet directly with me right now, but I'm here, as the cases proceed. So I'll just be sitting here boring you by doing paperwork. Okay. Okay. Oh, Mr. Matson's coming back in. So here we are. Mr. Matson, let me get Mr. Hug back over. Okay, Mr. Hug, Mr. Matson, where are we with regard to the single charge of walking in a road?
Judge, I believe I saw on a note that you would consider the time he spent in a rehab facility as community service.
Yes, it is.
Okay, then can we just do a deferral and apply those community service hours to the fine?
Yes, we may. Mr. Hug, am I saying the last name correctly? Okay, and you're muted, but it's perfect. I saw your yes, so I'm gonna assume that one, but there we go. Okay, great. So it looks like a deferral of 120 days with the credit being applied now that I have a plea of no contest. Is that right?
Yep.
Okay, Mr. Matson, is there any kind of course or anything that would be required here? I don't automatically see one.
No, Judge, I believe that the time spent in the rehab facility is sufficient for that.
I'm gonna just mute that wind, Mr. Hug, but the deferral, I need to get a signature from you. And it's a deferral for 120 days. That means that it would run from today until July 31st. And then as long as you don't get any more convictions or charges in the city of Temple and keep your address current, then I would sign a dismissal of this charge. Is that your understanding? And now you're going to unmute for me again.
Yes, ma'am.
Okay. Are you local at this time?
I'm not.
Okay. Can I email the order to you and have you print it, sign it, and email it back today?
Yes, ma'am.
Okay. Can we use the email that we used for the meeting today?
Yes.
Okay. Then we have a way to move forward. And let's see. Let me just make a few notes and make sure I don't have any questions. I don't think I do. And just a note for everyone, the credit applied as community service credit as completed today. So we'll get that deferred over to you, Mr. Hug, and Mr. Mattson. Thank y'all both for your time. Is there anything else that we need before we get that ready and email over?
Nothing from the state, Judge.
Mr. Hug, anything that you need before we move forward?
No, ma'am. Thank you.
Okay, you can expect that to be sent to you within the next hour this morning, okay?
All right. Thank you.
Run into any problems with that, please call a clerk, okay?
Yep. Sounds good.
Okay, bye-bye.
Okay. Bye.
Mr. Mattson, moving you forward, Matthew Baumfalk. Did I say their name correctly?
Close. It's Baumfalk.
Baumfalk, okay. Moving you forward in that meeting with Mr. Mattson.
Okay.
Yeah. You're welcome. And then I just need to do that community service credit. Yeah. Okay. Yes, that'd be great. Thank you. Thank you. Thanks so much. Okay. Mhm. Okay. He has the two cases, right? He has the two cases.
Four cases in total. Because of
These have the same number at the top.
oh
Mhm.
yeah, they have the same number but different charges.
Oh, I see. I'll be right with you. Okay. Let's see, where are we with regard to the single accusation of disregarding a flashing red signal?
Your Honor, Mr. Bonfalk has indicated he would like to have a bench trial.
Okay, let's come on into court to complete that paperwork, and we can do that on, I have several dates that we could do that. April 23rd or May 7th. Would either of those work for you? We do that at 9 o'clock, just to help with that.
May 7th would probably be better.
Okay. Okay, so I have that down, and Mr. Baumfalk, I will email that setting to you, okay?
Okay.
Okay, you're good to exit at any time now.
Thank you.
Thank you. Mr. Matson, I'm moving you forward with Vanessa Munguia. Ms. Munguia, can you just unmute so we know that your audio is working? Oops, nope, didn't work yet. There we go. Try it.
Yes, ma'am.
Okay, moving you over to that meeting with Mr. Matson. There he went, and there she went. Okay. Okay, where are we with the Mungia case?
Your Honor, we have reached an agreement on terms of deferral.
Okay,
It's going to be a 120-day period with a 6-hour course due by day 60. And Ms. Mungia indicated she can make payment in full by day 30.
okay. So that would be a deferral that runs from today until July 31st with a course due by June 3rd, and we'll send information for how to find a course and payment by May 2nd. Is that the understanding that y'all have reached?
Yes, Judge.
And Ms. Mungia, does that sound like what you are agreeing to?
Yes, ma'am.
Okay, can I email that to the email that we sent the meeting notice to today?
Yes, Your Honor.
Okay. And can you print it, sign it, and email it back?
Would I be able to do that by the end of the week?
What prevents you from doing it now?
Well, I'm in college and at my apartment, I don't have a printer here. I'd have to go on campus, and I'm not exactly sure where they're located. I just wanted to see if I could get some time to be able to figure all that out.
I'll have to have you reply to a request, an extension. I can extend you until April 5th. That's this Friday.
Okay. Yes, ma'am. Thank you.
So we'll send you, why don't you email the court actually and ask for time to send the order back?
Okay.
Send it to Court Online Help. And that way I've documented that you're acknowledging the date. And just ask in the email for April 5th.
Yes, ma'am.
And we'll still send that order probably back as a reply.
Okay. Thank you so much.
Do that as a reply. Okay. Let me make a note. So you'll email today. We reply with the order, an acknowledgement of the extra time. And that ought to keep us all straight.
Thank you, Your Honor.
Thank you. Okay, with that, then you are good to go. But don't forget to email us today.
Yes, ma'am. Thank you so much.
Thank you. You're good to exit when you're ready.
Thank you. Have a good day.
And you too. Mr. Mattson, moving you forward with Logan Mayberry.
Judge, before we move forward with that, Mr. Mayberry actually has submitted registration with late fees paid, so I was going to move to dismiss that.
Okay, you're moving to dismiss on the prosecutor motion?
Yes, ma'am.
Okay, I'll go ahead and generate that here in the court and email it to Mr. Mayberry. Mr. Mayberry, the state is dismissing the charge due to the compliance. We sort of talked about that generally in the general session a moment ago. He has made that request in your case, and I will sign that request for dismissal, and therefore I will email that to you and today, and with that, the case will be completed, okay?
I have a question.
Yes.
So I'll get an email of that. Do I have to sign anything or?
No, you don't. Good question. Yeah. No, you'll be completed.
And I won't have anything else to do?
You will not.
Okay, awesome.
Okay, that'll come to you shortly.
Yes, ma'am.
That here in the court. Okay, then you're good to hang up and you'll get that email here shortly.
Okay, yes, ma'am. Thank you.
Thank you.
Have a
And
good one.
you too, Mr. Marshall. I'm going to move you over to that meeting with the prosecutor, okay?
Okay.
Okay. Yes. Compliance in file. Mhm. Both. Just an added note.
They do have it changed their state, they're still standing everything March.
Sorry.
Okay.
Let's fix all that. I don't know why. I thought I did change it actually. But you're right. I did not. Heavens. Here we go with Mr. Mayberry.
Thank you.
Starting right there. You're welcome. Thanks for catching it.
That's it.
Yes. Thank you. Did I hand you a juror disqualification form? Oops. This turns into that 30-day community service order. I don't have any way of rolling her funds. This is that pretrial live show. Okay, we're back here, and Mr. Marshall, let me have you unmute. Thank you. Mr. Matson, Mr. Marshall, where are we on the single charge from November of FMFR?
Judge, if we could get a reset,
Okay,
preferably on Zoom again, to give Mr. Marshall some time to get some stuff turned into the court, that'd be great.
okay. Mr. Marshall, what would work best for you? I've got April 16th or April 30th.
April 30th.
Okay. Then I will, can I email that to the email that you have on file with the court that where we
Yeah.
sent the meeting for today?
Yes, ma'am.
Okay. That'll come to your email probably today. And, do you have any further questions for this court?
No, ma'am.
If you're turning anything in for us to make available to Mr. Matson, you are able to reply to any emails, especially to the help email, with any documents. If you don't have the ability to scan or take a readable photo, then you can come by the court and hand it to us here, and we can scan it to the file and hand it back to you, okay?
Yes, ma'am.
All right. Any questions?
No, ma'am.
We'll see you later this month, okay?
Thank you, Judge.
Thank you.